Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Hello, guys. Good morning. Welcome back to J is for Justice. My name is Jay, and I am your host today. We are going to be watching Bryan Kohberger's final pre-trial hearing. Good morning. Jenny's Chaos and Crime, thank you for becoming a member this morning. Kels, thank you for sharing 13 months of membership. I can't believe it's been 13 months, Kels. It seems like just yesterday. Good morning, Naomi. Looking forward to this live? Close your legs. That's right. A kind reminder to close them legs this morning, Cooters. What is happening? Jackie Bushable Baked Beans, September Pours, 15 months. And Lucy Craft, 6 months. That's amazing. Thank you, guys. Hi, Angie B. Hi, D Love of God. Hi, Maligator, Sarah, Sherry Baby, Denise. Melissa B. Angie B and Melissa B are like staples here. I love it. The sisters. What up, Diana? Diana's here. Thank God. I am so thankful for you too, Kels. I'm thankful for all of you. Danielle Marie. There you are. Hello. All right, let's watch this quick video. Night Angel, 11 months. We're almost 1 full year. Make sure you come back and celebrate when it's a year. Hey, Gertie. I appreciate that. I appreciate all of your support. Thank you. Hi, Katie. Let's watch this quick video. This is going to kind of tell us what they're going to be going over in today's hearing. Let's take a listen.
An important step in the case of the man accused of killing 4 University of Idaho students. You remember this story. Bryan Kohberger is due to go on trial this summer for those murders that happened back in 2022. A judge entered a not guilty plea on his behalf. Jonathan Vigliotti is in Boise, Idaho, where lawyers on both sides are going to go head-to-head one last time today before the trial begins. Jonathan, good morning.
Hi, Jonathan.
And good morning to you. Today could be a pivotal day for the defense, who has argued someone else was responsible for committing these murders. The judge has asked for evidence supporting this claim before allowing this theory to be introduced to a jury. Today we could learn what evidence, if any, exists.
Oh, for another perpetrator?
Bryan Kohberger is set to appear in court today for what could be his last hearing before his murder trial begins this summer.
All rise.
An Idaho judge is expected to focus today on what evidence could be presented at trial.
This hearing will largely be about what is the jury going to see, what are they going to hear, and who are they going to hear from.
Kohberger's defense team has suggested there could be other suspects responsible for the murders of Kaylee Gonzalez, Madison Mosion, Xana Kernodle, and Ethan Chapin. In documents, they say the case is full of alternative perpetrators and that many of them can be connected to the crime. The judge ordered the defense to provide its proof of another perpetrator by Wednesday, so it can be addressed in court today. Another key point, the state wants to admit dozens of pieces of evidence during trial, asking the judge to accept certificates of authenticity and receipts instead of using witnesses to testify on each. The evidence includes items like Kohberger's Amazon shopping records, his phone records, a college term paper he wrote about crime scenes, and a receipt from Dick's Sporting Goods. According to documents, that's where he bought a black balaclava, the same type of mask a witness describes seeing on the alleged intruder in the home the night of the murders. Jury instructions and questionnaires are also likely to be addressed.
What we want is people who can put aside any preconceived notions and look at the facts and look at the law.
And jury selection is set to begin July 30th. The trial is set to begin August 11th and could last several months. If found guilty, Kohberger could be sentenced to death.
All right, a lot of people are watching.
Wow. So we'll see. We will see. What's up, Sleuth Investigates? Sleuthy Investigates. Hold on. I'm going to give away 5 cooterships. 5 J is for Justice memberships. Let's do that right quick. So I don't know. We'll see what kind of evidence they pull out of their ass today. I'm really, really interested in this. So this is the final hearing before jury selection, which actually starts on my birthday. We will see. News Nation the other day was talking about him calling, talking about the certain things. What, Lee Michelle? All right, here we go. Here comes 5. I got 5 on it. Cooterships, memberships. Trixie, welcome. Look at, I knew Sleuthies would get one. I knew it. Sleuth Investigates. I knew it. I saw you. You weren't green. And I'm like, I bet if I give away memberships, she'll get one. You did. Britt, BJ's CPS worker, welcome. Marie Davis, Britt, and Say No to Globalism. Welcome back. Awesome. Marie Davis, I can't think of any more special people to grab a membership today. Your birthday's July 31st. You'll be 30 this year, Cole. Well, we shall celebrate your birthday. My son is July 30th, and he will be 30. You and my son are 1 day apart, Cole. Can I get a 5x5? Punani, what's up, girl? Are you here for it?
I did get choked.
Niggas wife me once they get that good punani.
What's up? Hey, True Crime. Hope you had a good birthday. Hey, Sarah. You'll be 34 on the 31st. Hi, Agent 99. Good to see you. Yep, of July. The 30th of July. I had my son 30th of July, 1995. That was my first baby. Yours is the 30th of November. Hello, Yoga Mom. Adrian Watkins. So this hearing will start in about 15 minutes. Oh, let me fix this filter. I've still got it on sharpness from yesterday. Hold on. I was going to show you guys my new mug, but it arrived damaged, and I'm kind of bummed about that. But the good thing is that Streamlabs, which is my merch store, they are really good at replacing things. But I'll show you the mug. Hold on. Let me make this bigger. So this is the this is the 420 mug. Ooh, damn, I'm banging the hell out of this microphone. But look how it came. There's a piece missing out of it. Who bit that? BJ, did you take a bite out of my mug? I think BJ took a bite. But anyways, it's got the J is for Justice with the cloud of smoke. And then it's got our little guy. But BJ took a bite, so I'm going to have to email them. I've never had anything come broken before. Your oldest is turning 30. We're all in the same boat. I'm loving all my fellow millennials in chat. I'll be 31 on June 28th. Oh my God. You guys are a bunch of babies. Here, let's go over to the court site. This is where we're getting our feed from today. Am I crazy? Yes, I am. Thank you. It is cute, but it's broke. Good morning, Robot. Come on vacation, leave on probation. Thanks, Sarah. And Sarah, thank you for your membership as well. Say No says, I use my J for J mugs every day and no one is allowed to use them. It is a cool mug. Take a bite out of crime. Take a bite out of crime. My son will become a teen in January. That's a big deal. Pancake will be 40 in a couple weeks. God, he's still a baby. Hey, John McKell. Hello, Jay. What a beautiful voice you have. Thank you. You're welcome, BJs. I do love the age range too. Like if I look at my analytics, hi Helen, hey Butter. If I look at my analytics, literally it's like the main ages are 35 to 65. I want to thank you. Thank you, Regina. I want one. Little 420 dude is so cute. Yeah, he's even got a little t-shirt on with a little leaf on it. He's cute. Hey, 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 Lori, it's a new day. Well, everybody wake up. I got poison ivy on your arm. Oh, God. Do you want to hear? Oh, I probably shouldn't tell that story. My son probably wouldn't appreciate it, but he got poison ivy when he was a little boy. It was horrible. Thank you, Regina. Hey, Liberty. Hey, Jojo. Hey, Lucia. Hey, Cricket. I know who killed you. So excited to see what the defense offers as alternative perps. Me too. 61 next week. Naomi. Hell yeah. Hi, Alyssa. You'll be 50 on Monday. 50. You are too damn old, Jay. I need that as a soundbite. I have a couple new sound bites I put in last night. I can't even remember what they are now because I was so tired, but let's see. I got September. That's not new, but hi, FSU. Did you see the FSU shooter's mugshot? His jaw's out to here. He finally got out of the hospital. Welcomed my third grandchild on Mother's Day. Oh my gosh, that's amazing. Congratulations, agent. And thank you for 17 months of membership. Congratulations. That's good stuff. 51 hit different. I'm 51. I'm going to be 52 in November. 52. I agree, September's. My granddaughter just turned 6. You can believe that. She lost her first tooth. It's crazy. You can't stop time. Deb K, I did. I was like, I better not tell that story. Aw, Regina's hubby agrees. I think it's merch. I finished up yesterday's live. The pentagram was weird as fuck. Crimology, was it not? Island Thrifties, 14 months. What's up, girl? In the Pines. Love my millennial daughters. They got a lot of the Gen X feralness from me and the mother of all music diversity. Mine too. My kids are all very diverse with their music. Something about us Gen Xers, we're just such a good influence. I can't say 50 normal either, I know. I'm 50. Last night, BJ talked about being 50. She said, that's a great age. I don't know why anybody would not want to be 50. It's like, wow, really? Member for 32 months, Lucia. You've been here for so long. Congratulations and thank you. You're an OG. Aquarius, you'll be 62 in next January. I know, FSU, I agree. You have a baseball team's worth of grandkids? That's awesome. I know, we are such a good influence. Thank you guys for all the support. Thank you for your support. I wonder who the other, the evidence of the other perps will be, huh? We got about 6 minutes. We got about 6 minutes. This is what we just watched. Yeah, CBS. I was just seeing if there's anything more. I don't think there is. I just can't believe this is the last court date until the trial. It seems like, I don't know. It just seems like this has been going on and on and on. And finally, we're here. The Idaho Statesman has an article, but you can't read it. It's behind a paywall. Hello, Tennessee Terry. Hey, Kiki. We really are. You know, I really love, like someone said, I really love the diversity of the ages here. The trial begins August 11th, and jury selection begins July 30th. Hi, Brendan. Hi, Pearl Strand. Hi, Rana. Thank you guys for hitting the like button, by the way. So when we start this, I'm gonna try to make it full screen like this. Oh no, I'm not. Wait, hold on. I'm gonna see. I'll make it big. We're gonna go full screen with it so you guys can see everything. Love Louie, that's a really good question. They did say that if it goes into, like, if it lasts longer, that they will go into tomorrow. God, I had a brain fart. Belinda. Yeah, it should be pretty beefy. So they said if they have to go into tomorrow, they will.
We're not mean.
Oh, that's one of my new. I forgot.
We're not mean. She's a wackadoodle. A wackadoodle.
A wackadoodle. I'm turning 56 next month and not looking forward to it. No, not a downside. It's never down. Celebrate that shit, true Texas girl. Celebrate your wisdom. Celebrate your knowledge. Don't ever look at it as downhill. The smarter you get. So nervous, but excited for justice with this case. Thank you, Garden Glitter, for your super chat.
She's a wackadoodle. A wackadoodle.
All clear for landing.
I need to send that one to Clue. Craig says, all clear for landing.
All clear for landing.
64 years young here. That's awesome. No one can take the mayor of Cootersville from Jay. Nope. What's up, Kels? Oh my God. Yes, reality. She never stops.
She's a wackadoodle. A wackadoodle.
Pearl Strand, celebrating lots of wisdom. Thank you for 4 months. They will say Kohberger was just the driver. You think, Chad Fletcher? BJ, I don't think so. I think she's got, a normal life. I used a different account and gave BJ a piece of my mind. She is full of drama. She's horrible. Deb. Jay, how's the weather? I'm flying back today from New York. It's so rainy. Hot. Love Louie. It's hot. I literally just went out to get this mug, and it's hot and humid. It's like all of a sudden it's gone from spring to summer for real.
All clear for landing.
Hey, Garden Glitter. Thank you for joining today. Thank you for your support. I appreciate you. The driver that unsnapped the knife from the sheath for him. Let me get that for you. I don't know. I think that this defense is grasping at straws, always grasping at straws. There's always something weird. They're always bringing up some kind of BS. 30 degrees, Danielle. Oh, my God. Yeah, it's really humid and hot. I wanted to say thank you, Jay, for making those horrible voices into bites that are hilarious and tolerable now. You're welcome.
We're not mean.
We're not mean. Tanny, I feel bad for them too. It's horrible. You're gardening? Nice. Vegan goddess. Get it, girl. Chrissy, good morning. Yeah, I mean, it's really hot. We're looking at tornadoes and junk. We're looking at tornadoes and junk in Kentucky tomorrow. Yikes. Stay safe. I hate that. I hate tornadoes. Jay, do you think Kohberger took any trophies from the house? I wouldn't be surprised, honestly. It would not shock me. Are we live now? Come on, people. It's 11 o'clock. It's only 1 p.m. in my neck of the woods. You got a whole day ahead of you, Brendan. I'm a smart woman.
We're not mean.
Wow.
You were born on July 30th as well? That sounds nice, Angie B. 83 is perfect. That's how our weather's been the past couple months. It's been beautiful. Low humidity and everything else. Come on. Kels has supported the stream with 25 bones. Thank you.
Kels has supported the stream using J4J Live, the best true crime around.
Thank you, girl. That is so nice. Thank you. J4J411.live is a separate tip line where you bypass YouTube and get that money right to me, and I appreciate it so much. It helps. Cheryl, good morning. HM, good morning. Regina just bought her mug. Look at, she says, I can't wait. Thank you, Regina, for your support. I hope you love it. I hope you love it. Friday morning for what, Brendan? Really, Terry? So is mine. What year, though? Mine's 95. I have a feeling your son's a lot younger than mine. Thank you so much, Kels. Thanks. I actually am thinking about bleaching some of my dreads, like to have them like multicolored instead of all just brown. Some of them are bleached a little bit, but like more dramatic, like for the summer, you know? Regina, it will be your favorite mug. It's the perfect size. They are the good size. They're 15 ounce. So here's the one from last year. I'm using it right now. The one from last year, 420 Puff Pass. But they're 15 ounce. More drinking money. I don't even drink, Brendan. You're crazy. What's going on with this hearing? Da, da, da. Yeah, it hasn't started yet. Okay. Jay, you see my BK trial shirt? No. Where do I see that? I think it would too, Cheryl. You got 5 inches cut off, Lucia? Oh, wow. Your hair must be really healthy. Brian Enron just tweeted it starts at 11. Yeah. Enron? And your phone corrected it and put Enron. I haven't heard about Enron in so long. Fucking Enron. Wasn't that like a big scandal? You would love to have really small ones? Mine are real. You can actually get like fake, like wool ones or fake hair ones. Jay, will the court be dragging the shackled monster in today for his hearing? No. He'll be in a suit. He'll already be seated when we see him. He'll be seated with his defense team. So no, we won't see anything like that. You shaved your head? You'll text me? Okay. I watched some of it, Kiki. It was funny. That's where I got this from.
All clear for landing.
Alan Miller. I'm new here and I don't know much about this case and looking forward to watch the trial as a juror would. That's amazing. So we're going to be streaming it beginning to end here on this channel right here. So make sure you're subscribed and all that good stuff. Let me see. Oh my God. You do not have this, do you really? Burn Bundy Burn. Bundy's last charge in life. It's a picture of Bundy. January 24th, 1989. In the... Wow. Dude, where did you ever find that? She's got a shirt from Bundy's execution. McKenna says, what's this hearing about? About a lot of things, but mainly about other perpetrators. So they're going to be able to bring evidence of that somebody else did this. Island, that's amazing. Oh, Brendan, I got you. Enron was a huge financial fraud. Exxon was the oil spill. Enron? Enron. I bet it looks cute, Lucia. And whatever makes your life easier. You know what I mean? And I bet it looks adorable. Lucia, you're so cute. I think she has zero evidence. Me too. Me too. Bundy was creepy as hell. Did anyone like him? No. Good morning, Laura B. Michaela, nobody else did this. LOL. Did what? Uh-oh. Are we live? Live? I think we are. Nope. I just saved my head. I felt like, I just shaved my head. It felt like a weight was lifted off. Don't think that I haven't thought about it. Are they going to blame the DoorDash driver? I will, Pearl Strand. Pretty, Katie. I love it. I love being able to change things up. Michaela. Nobody else did this. Oh, yeah, I know. But he's claiming someone else did, right? And if you see me over here with Windex, I got a burr up my butt. And I want to switch up my studio. So I'm going to start cleaning. It's like spring cleaning time. I got to clean this desk. And I want to get some kind of different shelving behind me. I just want it a little bit different. I'm never happy. I'm always wanting to change things. I just wish he would change his plea. He won't. Even if they say he was the only driver, he would still get charged with something, right? I don't know, Vicky. Well, that's the thing, okay? So, I hope this doesn't start while I'm talking, but let me read this to you. I saved this last night. I thought I saved it. Dang it. I didn't save it. But it was the time frame that he almost would have had to cross paths, because I think he came in at like 3:59. Or no, Bryan came in at 3:58, and I think DoorDash came in at 3:59. Oh, I agree, Danielle. He freaking loves all the attention. That's why he's played so many games. If you were going to kill somebody, how would you get away with it? My parents offered me their guest room for the trial, but I can't miss that much work. Well, maybe you could just go for a little bit. Like, you don't have to go to the whole thing. Maybe go when just the defense is calling their witnesses, you know? No, Lindsay. No, I just want to switch things up because I just feel like it's unorganized. Hey, Shauna. What is the holdup? Good morning, Dina Weeks. My Muffin, thank you for subscribing. Like, you could just go for the defense witnesses, which would be interesting. Or go when, oh my God. So we have some drama here in Clearwater with Scientology. They want to buy another building or a block or something in Clearwater. And all the residents are like, no, we don't want, you're done. Like, Clearwater is more than Scientology. Sue M., thank you so much. Well, I just saw a news report. Church of Scientology drops application to buy Clearwater Street. So now they want to buy the whole street. But they had this meeting and all these residents got up there and they were pissed. I need to tackle my closet too. Yeah, they were like, you guys have enough. Yeah, apparently they want to buy this street. Here, let's listen to it.
We've got a big update this morning. The heated debate over the Church of Scientology's request to buy a city street in Clearwater is over.
At least for now. Our Kaylee Tracy has been following the story all morning long.
They withdrew their application. So they're not.
So breaking developments, right?
Interesting.
Yeah, good morning. Just a little while ago, Mayor Bruce Rector let me know that the church late last night, it withdrew its application to purchase the street here behind me in front of their flag building, and also its request asking the city to close that street to the public. The street in question, as you can tell, it's in the middle of downtown Clearwater. This main road goes out to Clearwater Beach. Any of you have traveled this area, you're familiar with that. South Garden Avenue between Court and Franklin Streets. The church wants to build an auditorium and a park next to the street.
An auditorium.
And it said they needed to close the street to the public for safety reasons. Now, in a letter to the city manager, which we just received, an attorney for the church said it wants to give more information regarding those safety concerns it has surrounding the piece of property, and it wants to review the issues around its request closer. That is the reason for withdrawing the bid right now, possibly signaling that this bid for the street, it may not be over just yet. But for now, at least today, that vote will not be happening. The latest move by the church comes after Monday's work session, where for one of the first times the Church of Scientology came to City Hall. The church told the council almost 10 of the church's buildings at least have permits for work to be done in downtown, and featured them in a video shown at the work session. The church owns around 200 properties in downtown. That 200? Video, though, it didn't talk at all about this street in question.
They own 200 properties in Clearwater.
The church wants to buy, and city leaders, they pointed that out, saying they've had more than enough time to redevelop, and still several storefronts sit vacant. Mayor Bruce Rector says he thinks they may have seen the writing on the wall after council member David Albritton said Monday he was flipping his vote from a yes to a no on the sale, which would mean it would not pass, at least in this go-around. Here's what Albritton said Monday.
My patience is running thin. My eagerness to initiate an active downtown may have clouded my judgment regarding trust in Scientology's plan.
Hey, Jax.
However, I find it difficult to trust them to execute this plan when they won't even share the complete plan openly. Moreover, my stance on a sale of the public street has shifted as I reflected on what was promised compared to what has been revealed.
The grassroots group Reconnect Clearwater just recently submitted a counter proposal for the street called Save the Garden. Those plans include a park honoring African-American history in the city and everyone who helps build Clearwater, but it faced scrutiny Monday as well. And Mayor Bruce Rector saying this morning Reconnect Clearwater actually did not file their own application.
Anyway, yeah, so the Church of Scientology's headquarters is in Clearwater. We've got like John Travolta walking around these streets. Yeah, it's weird. And I think Clearwater, they're like, we don't want to be just Scientology. Well, it looks like we are still waiting for this to start. I sneezed so many times yesterday. I don't know if it's pollen, what it is. You want to see something weird while we wait? Jax Wolf, thank you for becoming a member, buddy. I appreciate you so much. Wasn't there a fire in Clearwater a few days ago? I don't know. I think there was fires in St. Pete. The Scientologists have really made downtown look nice. Yeah. John Travolta was in Ocean Springs, Mississippi a couple weeks ago. Ugh. They all give me the heebs. Scared to talk about them.
For landing.
You guys want to see something weird that I clipped this morning? You'd be surprised who's in Scientology? Really? Oh, look it. We've got it opened up. There we go. Let me get this situated for us. It won't be long now, folks. It won't be long now. Let me show you something weird. So Trump went to the Middle East today. Hold on. And there was this weird ceremony when he walked in. Did you guys see it? They went after Stephanie Harlow? They did? Really? Now that I did not know. But check out this weird ceremony. Dina Weeks, welcome in. Thank you for joining. I appreciate your support, Dina. Okay, watch this really quick. Why do they have an 8-year-old girl giving him flowers? Yes, sleuths. Yes. Flipping their hair around like they're headbanging. Weird shit. You might need your tinfoil, yeah. Watch Trump clap at the music. Watch. Watch when they play the music and he claps. She did one video on them. They're not women though, Sleuth. They're girls. I know, watch him clap. Watch. So stupid. I don't trust it. Like, what is this? That shit's weird, huh? Some weird shit. I don't trust any of them people. Who is it that gave Trump a plane? Look at, they're waving swords. They're waving their hair around. These girls are young, too. Yeah, what the fuck? I'm glad you're covering this case. Kohberger's autism defense does not make me happy. Thank you, Skolnick. Let's go back to Kohberger. Isn't that weird? I don't like it. And I don't trust them people. Like he was given a plane or something, and they don't want him to take it because of security. Where did my video go? Hey, Julie, by the way, good research yesterday on the kids case, the Sullivan, finding that story on the aunt. That was really interesting. Love Louie, thank you for joining. Oh my God, I whip my hair back and forth. I whip my hair back and forth. Some of them look like they were 8 years old. I don't know. Who's that, Robat? Who is that? Did they really, Alan Miller? The Prince of Saudi Arabia? Yeah. He's like, well, it's free. I'd be stupid if I didn't take a free plane. I don't trust it. I wouldn't take nothing. Yeah, I agree, globalism. Mother McReady. Thank you, Danny, for 231. Thank you for being here. Recap what has happened so far. Nothing. We've been waiting for this to start. I whip my hair back and forth. I whip my hair back and forth. They marry off young there. Yeah, very young. Yeah, I don't know what that's for. Is that like a new thing? Like, oh, we're free. Nothing to do. Oh, Trojan horse.
All clear for landing.
They have to completely gut the plane. Why do they even want to give us a plane? He said there's no inflation. Shows he hasn't bought eggs lately. Or anything else for that matter. Yeah, why are they starting so slow? Did anyone see the person BK almost hit? I didn't. Not in that footage, I didn't. Welcome back. Welcome back. We're still waiting. Trump signed a deal with Saudi Arabia and said he will remove all sanctions off Syria. I know. It just keeps getting wilder and wilder. Sometimes doesn't even seem real.
What you are witnessing is real. The participants are not actors.
Hi, jammers. Yeah, so Kohberger, I guess, when he was pulling out, I don't think it was Linda Lane, was it? It was Queen Road. It was Queen Road. I'm going to smoke him if you got him. Smoke break. Katie Horton, you got horseflies? Oh, you did? Idaho Charlie. Huh. See, now I didn't zoom in enough and analyze that. Where did you think you saw them at? Hello, Miss Evelyn. Robat, I always question it too. I always see things like that, like watching that clip, right? I was watching that clip of Trump and them, and I was like, is this just a big production? Are they like in a, I don't know, like a set? God, you guys are going to think I'm off my fucking rocker. But I was watching this and I'm like, you guys ever done that? Like, you look at stuff like this like this. Like they're literally in like, where are they? It just seems like a big production. Like, oh, and look at this young girl. That's what I was talking about. These girls are young. Why don't they have women out there? Why is it all young girls? I don't like it at all. I don't know. It just all seems staged. Like they already know what's going to happen. They're just going through motions. I don't know. You do, Robat? I don't know why. I mean, look at they're wearing New Balance and shit. Like, what is this? Look at this dude's got New Balance on. I mean, I guess be comfortable, but shit, that's weird. It looks like they dressed up for a fucking play. Thank you, blessed Gigi. I whip my hair back and forth. I whip my hair back and forth. I don't know. I question everything. I don't trust shit anymore. Call me crazy. But that's where the hell I'm at. Still waiting. I don't know. I'm pretty, perhaps we should just look up the ritual in Saudi Arabia. Be right back. As my husband says, it's all in the script. Aw, loves to lurk. I love Clearwater whenever we visit. I always stay at the cute little Dolphin Hotel. Such a beautiful place. It is. Heather, to be honest, it looks scary to me. Yeah, Lindsay, I'm curious too. Good morning, Lovey. Surgery went well, now in the recovery stage. Yay! So far, I'm seeing stuff I hadn't seen in 2 years. That's great, Lovey. Congratulations. They do that dance at weddings, too. I mean, is there an age limit for the dance? Hey, Chinlo. Kaliji dance. Spitfire, good morning. Oh, my God, Diana. I don't know. Maybe they're settling some things outside of the cameras, you know? It's a traditional folk dance. I'll take your word for it. I will take your word for it.
You can't talk to a fucking log.
Be nice, try it. Thank you for becoming a member. Thank you for your support. Be nice, try it. You're really a good person. I see you in all kinds of chats and you're always consistent and a good person. I'm going to have surgery after they do another CT scan. I have a nasal polyp. Oh no. Hope everything goes well with that. Looks like possibly the terminal. That was in the airport? Oh Lord, Sluice. Did you really, Julie? Al and I stayed at the Don Caesar 2 years ago in St. Pete's. I've never been in the Don Caesar, but I've heard it's haunted, Julie. Did you see any ghostesses while you were there? I've never been inside. I think it is, Vicky. I think it's their wives. They have many wives, don't they? I know, very fancy. Tempest, late start. For sure wish they showed him coming in the courtroom. I know. Bless Gigi of 10. Jay, thank you for covering this. I am from Moscow. This is great. Oh, wow. Jay, did you go down the Jamal Khashoggi rabbit hole? No, I don't even know who that is, Jax. Jay, I emailed you the story. Thank you. Nevermore. Well, hopefully you'll feel much better afterwards. Yeah, go toast a bagel, Lucia. Heather, we have them right in the bin. If you need to pick up a tinfoil hat, they will be off to the side in the bin if you need to grab one during the stream. We're here for you. We got you covered. Get your snacks. Hey, do you guys... I don't know who Jamal Khashoggi is. Why have I never heard of that? Nice, Julie Skolnick. The main movements of Khaliji are done in a very feminine and rhythmical way. The main body parts involved in the dance are the hands and the head. Okay. I'm near St. Augustine. They have the best Halloween events. Oldest city in the U.S. It sure is. St. Augustine's beautiful. I'm sorry, I don't know who that is. Oh, no, true crime. Your doggy wanted some caffeine, wanted a little pick-me-up. You know what I had the other day? Have you guys ever had chia pudding? I got it this time from Tropical Smoothie. The chia pudding bowls. Oh, my God. I don't like those acai or whatever, acai bowls. The journalist that was killed for not liking MBS. Who's MBS? I feel so stupid right now. Thank you, Kels. We got 5 memberships coming in hot. Chinlo, Vicky McClure, Heather, Lovey, and Blue. Welcome to J is for Justice memberships. The seagulls in my area were aggressive. Were you eating, Julie? Welcome new members, and thank you so much, Kels. The Crown Prince of Saudi. I used to make overnight oats with chia seeds. Oh my gosh, so good. I don't like the acai. I don't like that stuff. But the chia pudding, okay, so it was chia pudding with oats. And then it had blueberries, granola, honey drizzle. I can't remember what else on it. Oh, what was it? Oh, coconut flakes. So good. Tuius. Hello, Jenny. When does the hearing start? We are waiting. It was supposed to start at 11. King Kwarar. I don't know a lot about them. I'm sorry. I feel really stupid. Tea-money. Okay, come sit by me. Oh, the boba tea. I don't... Ugh, that looks gross. I've never had it. Little Boston. They might be doing some things outside of the camera. We're not sure. Thai chicken wrap. I've never had their food. Chia.
State v. Kohberger.
Here we go. Right into it.
Defendant and counsel for both sides previously identified are present. We are in the public session now.
Let me turn the volume up. Hold on.
I have my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today other than, I think, the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want, and that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I, particularly where I can't recall whether Ms. Massoth has had any trials with me or not, but I know she's been in front of me a few times.
Hold on.
But the rest of you have not, and so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial. For a couple reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have.
He's blinking, though.
So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on an instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Herwood facilitated the defense viewing it yesterday.
Okay.
It is available for the court's inspection well if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse. I think that was an inappropriate characterization.
Yes.
It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but
Get some couth.
that's simply not an appropriate way for it to be described.
No, it's
given
not.
what occurred there and the
It's not a fucking dollhouse.
I think a better term is simply a model,
Yes, sir.
rough model,
Wrong with you.
given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Your Honor, we did. We were able to bring 2 experts in per our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in
I
as a
see.
demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
My God. Are they going to have little dolls too, for fuck's sake? That's weird. The DA should know better than to talk like that. Ugh.
The other thing that I would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is, in the middle of, for example, trial, well, Your Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire, so that they don't just get a list of 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, these, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient, because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Front row looks like reporters. Even maybe the second row. I think, is that Lauren from Hidden True Crime on the end? Second row on the end.
June 18th, Ms. Massoth has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday, and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not.
I missed him looking at the camera.
That's my concern.
Hey, Sarah.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons, if we could avoid that date. If we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
Ugh, Jesus.
12:30 or 1. I'm in federal court.
All right. Let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Oh, God, not Smiley McSmileson.
Let's do 12:30 on the 18th.
This should be her first priority, right? It's weird that she always has some other thing going on. Like, this is a huge case. I'm in federal court that day. No, Delaney, she never does. Ever.
All right, next I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I won't ask you if you have questions now, because I suspect it will fit into, if you do, a more specific category, and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance.
I don't believe so, Your Honor.
No, Your Honor, thank you.
All right, juror questionnaires.
What just happened? What's going on here? Did we get cut off? What the fuck? So they didn't have anything for the alternate perpetrator today? What's going on here?
I think it strikes that balance, but if you have any concerns about what we are asking or what we are not asking, please provide those concerns.
Ashley Jennings.
Say like by Tuesday, Wednesday of next week. And then what I will do is, if it appears there's enough flesh on the bone to merit a hearing, we can have that. Otherwise,
Flesh on the bone.
I will simply provide you back a version that, to the extent it incorporates any of those requests.
Yeah, what the heck?
Which leads to the next question. I think I talked to you about both previously when you were here to visit the facilities. Certainly counsel and the defendant, though it is an administrative proceeding, have the right to be present. But when the questionnaires are administered, but I suggested to you that perhaps your time is better spent in reviewing the questionnaires than watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to counsel on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
What's on Santa's
Thank you,
time?
Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Does that accord, Ms. Taylor?
It is, Your Honor.
All right, very well.
Where's Jay Logston? Where's Jay Logston? Is he no longer on here? Jay Logston, he was useless. He was so useless. What happened to him?
So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms.
This judge's mouth. It's so gross.
The plan will be to take the universe of jurors
Hey, potato.
who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence for that, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires. As I'm sure you're aware, pursuant to Criminal Rule 23, those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes, but the copies you receive will be returned. And the defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have
He only
3
moves
that are
his
working on the
eyes.
case. We would request our paralegals be allowed to assist us. just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality because it is part of what I'm giving the jurors on the instructions, is letting them know that there's a very limited number of eyes that will review this and that the public never will. So. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat.
Get to the wheat.
Any questions about the juror questionnaire process?
Sir.
Hasn't BICA always been there, though?
So the next topic I have is voir dire, more specifically. Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to, but the idea is after that more group discussion, individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question?
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case-specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment and that one that it's clear that they're not qualified, either one side of the coin or the other. But if you want to deal more, if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how that question will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit, because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is, and I want to protect the juror's privacy as much as possible in that regard, and so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only. and there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we want
They'll
to
have a
register?
laminated paper, like 8x10 paper that has cardstock laminated that has the number on it.
Thank you.
And it'll be the scramble number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, and let's say that number's 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then exercise.
That have been passed for
peremptories.
cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between.
Drink some more water, Judge.
Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything. If you both pass on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if the juror, if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as
thank you so much,
potentially
Sophia.
available for us to use, that you're not there.
Oh, Your Honor, we got an Airbnb with Catherine Ramsland.
If you intend to stay at a hotel, if you intend to put witnesses up at a hotel, if you intend to have staff stay at a hotel, let us know where that's going to be. You will each be assigned a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process or the jurors.
No, sir.
No questions, thank you.
So the trial itself, the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30.
So that would be
Once we
10:45
hit
Eastern.
a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that, and I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this, this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I had talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are
That's my birthday.
holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time.
Damn. Y'all gonna be eating turkey in the courthouse.
Any questions about that trial schedule? Okay. All right, in terms of special needs that you may have for trial, I'm assuming there is no need for us to have interpreters for any witnesses.
No, sir.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device.
Elmo.
Which is the device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring. All right. Let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have two counsel table kind of put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well.
No.
How many seats do you need? How many seats are you requesting and how many seats do you need are two perhaps different issues. But in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you? For the state, likewise, 3 seats, 4 seats?
We should be able to make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating.
Mom, Dad, and
What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, is for those that have reserved seating, in particular the victims, and I should point out I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media. But if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom.
You have to get tickets with your name.
Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later, to go over sort of what that process looks like, so that gets, so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench.
So 4 views we'll get.
There will be no production of the video, meaning there'll be no close-ups and zoom-ins and zoom-outs and things of that nature. It'll be the static views.
Before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator, and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them.
Oh, Ramsland.
Media might try to talk to them a lot.
All right. I don't have a problem with that.
Oh, Lord.
I'm assuming the victim witness coordinator
Captain
will
Ramsland.
want to be there as well. So.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrio's office to let her know.
Are you talking about one per family?
Hopefully not like that, but we're going to need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium. But
yes, understood. Right. Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this, at least in passing, in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that a public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be undesirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to give Your Honor a heads up.
Your Honor, this case is very high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face while they testify, and we may approach the court with a stipulation for certain numbers of them.
Well, my intent would be with respect to victims, and I've already indicated I think the two roommates are victims. There is a compelling interest to protect them, and so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I gotta see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right. And their hesitancy can be overborne with a subpoena. And that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Your Honor, I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group. I mean, it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, that's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict that may be reached in this case is for the public to have the ability to see the evidence. So I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
All right, any questions about either the seating or broadcasting besides what we've talked about?
No, sir.
All right, let's move to then opening statements. Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement. So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and we'll be back. All right?
Break. Jesus. Y'all started late. All right, we're on a break so we can discuss. All right, so the fifth person, let's talk about this because I think that is got to be Ramsland. It matches the rumor, okay? She came out and admitted that she did call Kohberger's family, so Howard Bloom didn't have it wrong because he was spot on about her. What scared you? Oh, objection? Yeah, that was me. Objection! I'm just trying to lighten up the mood, wake you guys up. The judge is putting us to sleep. Just sitting here dusting. But, okay, so let's talk about it. The reason I think that it's her is because, think about it. She admitted that she did call Kohberger's family, but she said, oh, I'm not guiding them, right? I'm not guiding them or whatever her verbiage. I can't remember what. Damn it, I just ruined this picture of my son. Damn it. I got Windex in the picture. Look. Okay, hold on. Look what I did. I'm so mad at myself. See the bottom? I got freaking Windex in it. See that? I'm so stupid. So anyways, what I was saying is she admitted to talking to the Kohberger family, right? She said she did it. But she said, I'm not guiding them. I'm not assisting them, blah, blah, blah. So we know that at least part of that story was true. So there's truth in between the wording, right? So then Howard said that she was emailing with Kohberger. And she came out and she said, oh, I never emailed with Bryan. Okay, so is there another form of communication she was using? Because that woman is like a criminal psychologist. That's her mind. So, thanks, Lucia. Aw, thanks, guys. I feel like I look ratchet. I'm going to shrink myself just a little bit here. I can't believe I did that to that picture. Hey, Cutsies. Hey, I was watching Molly this morning. She's so funny. She was on all fours on a chair. I don't know what the fuck she was doing, but I cracked up. I know. I usually do that too, Angie. And I was like, oh, I'll just spray a little on there. And of course. Right. So it's all in her wording, right? So then we have Ann Taylor today saying, and let's go back and listen what she said. Because she said, we need 5 seats. We need 5 seats. Let's go back. I don't know what the fuck she was doing, but I cracked up. I know.
We're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system.
Semantics game. Mm-hmm. She used to do phone interviews with BTK. Right. She did a lot of video calls, if you will.
On a computerized basis.
Yeah, she specifically said email. I did not correspond with Bryan Kohberger via email or whatever.
But we'll assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact that week. And if the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website
a human
each day
table
and at a certain time, and it's kind of like buying concert tickets, indicated who you are.
You have to get tickets.
So that
it's right after this, I think.
At this point is to allow a stream of the trial proceedings to be run on the court's.
God, he's slow.
include council table of the feature. It'll be the static views.
You're right, Sluice.
Before the
I mean, oh, did you see him look Ann Taylor up and down? Oh, my goodness. Why can't you guys see it like I can? Hold on. Watch him look. Look.
Court goes further.
Oh, that was so icky. Oh, God. Watch him look her up and down. Watch. Watch. God, his nose is crooked. Damn, Bryan Kohberger. Did you see that shit? That was creepy.
Before the court goes further.
Oh, he looking her up and down. He likes some Ann Kohberger.
Before the court goes further, when we're talking about the reserved seating for families, if we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here.
Why do I have an extra Kohberger?
Seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them.
Oh, Ramsland.
Media might try to talk to them a lot.
All right. I don't have a problem with that.
The media might try to talk to them a lot. So some nobody that nobody knows who they are, the media is not going to want to talk to them. I'm calling Ramsland. I'm calling it's fucking Ramsland. I think she's been playing the semantics game. I think y'all are right. Nope. He's an onion. I really do think it's her. Who else is the media going to want to speak to other than her? They're going to want to know why she's there. All kinds of questions for her. I know one is bad enough. Dude, do you think she looks at him like a mommy? Or he looks at her like a mommy or a lover? Do you think he's looking at her like a lover? Like I could see them together in real life. That's how weird they are. She's really scary. Yeah, it's got to be her, man. All right, I'm calling it today. May 15th, I'm calling it's going to be Ramsland sitting there with Michael, Marianne, Amanda, and what's the other one's name? Oh, really? Your oldest daughter and I have the same birthday? That's awesome. It's a good day. You should do a short on that up and down moment. I bet AT sees it anyway. Oh, I should, Happy Camper. I will. It could be both. Yeah, like Norman Bates. Jay, message Howard after this. I know. I need to get Howard back on. I'm going to email him right now, actually. Because I'll forget. Helen, thank you for your generous donation to the PayPal. Thank you so much. I appreciate you. All right, let's go to my email. Let's find. Do you know I still get I still get emails about the Watts case. Snazzy Trinkets, thank you for your $20 super chat. That is really generous of you. I think it is unethical as fuck to have the past instructor of defendant and criminologist, the serial killers of the world, sitting on the trial. Honestly makes BK look more guilty in my eyes to have Ramslin on board. That's so true. Especially after her books with BTK, right? Kind of makes it look like, oh, I'm just waiting for him to be on death row so I can interview him before he goes in front of the firing squad. Pew, 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 pew. What song? What song? I'm looking up Howard. I can't remember how I got in touch with him. Here it is. He has someone that does his emails for him. Bettina. Hello, I would be interested in having Howard back on the show. Let me know if there is any availability. Okay, sent. We'll get Howard on and we will talk about this latest thing about that. Clip it real good. I don't have it. Is Potato still here listening? If I was in his family, I would not want to be in there. Knowing he did this stuff to impress her in her classes, I think they're very twisted. Let me lick you up and down. Oh my God, I'll put that song in there, Angie. Shit, y'all are bad. I will. Think I won't, Angie? I got it down. I can't even find paper. People give me notebooks. I can't find them. Tell him you think his Dateline theory is correct. Thank you for the reminder, Robat. I need to get that back. Cut a clip. Clip it real good. Will be called that damn... Oh, I know, a dollhouse. Oh, yeah, he is charged with burglary crimes. So when he broke in, that's the burglary part. He didn't murder the survivors. He broke into their home, right? So he's charged with burglary and 4 felony counts of murder. Oh, man, September. Is there any way that we can help? Ooh, mac and cheese. Why? Because the judge sounds like he's got it in his mouth? Yeah, so there's a burglary charge, which kind of makes sense when you think about it. But then one has to ask themselves, did he take anything? Did he steal anything? Because isn't breaking and entering like just going in somewhere? Burglary, you'd have to like take something. Jay, remember when Ramslin was hard pressed, the BTK doc didn't use more of her interviews with BTK because she has 20 plus hours? I remember. She loves herself. She thinks that she is very smart. The only thing she hasn't done is go through with the act of killing someone. Other than that, she's all into everything around it other than actually doing it. No, we don't have an amount of witnesses. Everything's sealed. Do y'all still eat Kraft macaroni and cheese or no? Burglary is prowling, not necessarily thievery. Oh, thanks. I didn't know that. I wonder if he was asking her questions. I mean, okay, let's also take it a step further with Ramsland, okay? He had his survey, right? And we know that now a criminal had answered the survey. I don't know if you guys saw my video. Seems like my videos never get seen. It freaking pisses me off, but at least they're there and I can show you. This one here, it's 54 seconds long. Listen.
Yeah, we got a letter and it had a phone number in there, and we called this individual, and he said he had been interviewed by Bryan, and he got the sense that Bryan was getting off on his story, and his story was basically he'd listen to a police scanner, wait for somebody to call the police on a domestic violence type thing, and then the male would be arrested, and then he would go into those neighborhoods, and that would be the house that he would rob. So he said that Bryan seemed to enjoy his story, and he said that he had he felt like he started enjoying certain aspects of his story where he would talk about drunk females passed out, and he basically said, I could have done anything. I was just going for jewelry, going for money, going for whatever he was. But Bryan would call him back repeatedly and want to know more details on that story.
Right there. That's what I think he liked talking to Ramsland. I think that he loved asking Ramsland about BTK. That's my prediction right there. That he often wanted to ask her questions. If he's asking this guy that committed these robberies, why wouldn't he ask the woman who sat down with BTK for 20 plus hours and has spoken to him for how many years? At least 5 years. You would think he'd be asking her questions too.
Bryan seemed to enjoy his story, and he said that he had he felt like he started enjoying certain aspects of his story where he would talk about drunk females passed out, and he basically said, I could have done anything. I was just going for jewelry, going for money, going for whatever he was. But Bryan would call him back repeatedly and want to know more details on that story.
Call him back repeatedly. I don't know. Yeah, he can use the excuse that it's his job. I mean, that's a good way to figure things out and be under the radar, right? Because if some weirdo who doesn't have anything to do with criminal justice is asking all these questions about murders, he might just look a little strange and out of place, and people might just side-eye him. But if that's his job, see, the dude ain't dumb, right? He's very calculated. He's very calculated. That's the thing. Like, he knew he tried to cover for everything, right? You can't say I was at, the house. My phone was off. I was over here in Wah State Park. Oh, was Papa Rogers Ramsland? I don't think so. I don't know. Fuck, I don't know. I mean, I don't know. I don't know who it was. September, if you want to post in the help desk, we can help you get in. Can someone put the Discord link? Right, just studying, guys. Nothing to see here, guys. But I could use your expertise. And don't think for a minute that Bryan Kohberger doesn't know that Ramsland loves to talk about all of her knowledge. Do a Google search right now for Catherine Ramsland podcast. How about I do it? And I'll show you. He knows that she loves herself and loves to talk. So if he's stroking her ego, asking her questions like, oh my gosh, you have this information, you have that information. Look at this. I put in Catherine Ramsland podcast. Want to see? Look. See them all? Conversation with Ramsland. Wicked Words, Ramsland. Ramsland. Conversation with Ramsland. Catherine Ramsland. Lehigh Valley with Love. Interview behind the mind of BTK, the serial killer's apprentice. Last podcast on the left, How to Catch a Killer. It goes on and on. Bryan Kohberger. Oh, that's not it. Catherine Ramsland. Exclusive interview with Jill. MFM. Candyman's accomplices. Ramsland on this show with Styx. TikTok Live. Catherine Ramsland talks about the connection between serial killers and suicide. I mean, she's all over. All over. She ain't scared to talk. Murder Shelf Book Club Pod. Turning True Stories into Fiction with Catherine Ramsland. Murder for Mentorship. BTK killer Dennis Rader. I mean, she's everywhere. She deleted her ex. Yep. She wasn't Ramsland on a podcast a few days before or after the murders? Yes, she was. Yep, I put a compilation together. We went over a whole live stream of her podcast where she was like, we're not talking about Bryan Kohberger. It's her job to do podcasts. I thought she was a professor and a writer. I don't think they have to do podcasts. She's very, very proud of her BTK work. So all I'm saying is Bryan Kohberger could have known that, how proud she was, being that he was taught by her. He knew the extensive relationship she had with BTK. He could have had a lot of questions. No, not Candyman Killings. This is her new book. I'll show you. Candy. Oh, Ice Cream Man. Maybe she did do Candyman. The Serial Killer's Apprentice. Sounds like that was who Bryan is, an apprentice. How to Catch a Killer. Confession of a Serial Killer. The Sex Beast. The Sex Beast. That's another one of her books. Inside the Minds of Serial Killers. The Mind of a Murderer. Forensic Psychology of Criminal Minds. CSI. The Psychology of Death Investigations. I mean, this is right up his alley. I think that page 118 was one of her books, too. Remember when they collected a book at his house with page 118 underlined? I think it's one of her books. And then they also collected DeSales papers, and I think the sales notebook, if I'm not mistaken. $70 books. That's a lot of books. I don't know. You just have to listen to her talk. I think she's more than invested in this stuff. Hey, Chris. Good to see you. Hey, Beans. Yeah, I think he was Papa Roger too. If you post in the help desk, we can help you. September. Gypsy or somebody will help you. There's always someone in there to help. Thank God. because I'm not a Discord professional. Oh, God, Lindsay. Do you think so, Sleuth? Because sometimes I get really disappointed. I think that like all this sideshow stuff on social media will come out, but I don't think it will. If it's not relevant to the case. Yeah, I can, Robat. Hopefully I can get him on. We can talk then. I always think that we're going to find out all these ins and outs, and I just don't think we will. Like, I don't think we'll ever know. I don't think Papa Roger will be brought up because I don't think that they need that. Like, if they're relying on social media posts from Papa Roger as evidence, I mean, maybe to be brought up, I don't know. I mean, I hope it is, but I'm not getting my hopes up because those little mysteries are like the most intriguing to me. And I don't want to get my hopes up thinking I'll have the answer and then be disappointed that we may not ever know. Unless we can get all of the discovery like we did in Watts. Can you imagine? Oh, it is? Can you imagine? Shit. Thank you, Pone.
By 5 o'clock each day, you need to give notice
How much
to
did we
the other
miss?
side, the witnesses that you will be calling that next day. If it's over a weekend, by noon on Saturday. The list should be a realistic one and not everybody on your witness list. And it should be tiered into two. One is the ones that you definitely are going to be getting to. And then if you have time left over, who you would take and in what order. I do like to use the time efficiently, so I don't generally grant the request if we're normally stopping at 3:30 at 3:10 or so to say when you end a witness, well, can we just stop here? The answer is generally no. Let's use the 15-20 minutes that we have because in a 3-month trial that adds up at the end of the day. So have enough witnesses ready to go to fill the time. And it's always good to have one or two who you always have at your side. So for example, if the state, a law enforcement officer, who's there, for example, you can call and put on something if worse comes to worse. But I want to make sure we use that time efficiently. With in addition to giving the list of witnesses you're going to call, you need to provide a list of exhibits you intend to introduce with that witness, short of obviously impeachment, so that the other side can look at those. That doesn't include exhibits that you would put in as part of redirect examination. So for example, the defense in the state's case, cross-examines on some other exhibits that you didn't bring up, or there are exhibits that you didn't bring up that would explain what the defense brought up. You don't have to give notice of those exhibits. You don't have to anticipate that, in other words. Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster. I will give an example that I have used, that I have violated my own rule in the past. When I was in your shoes, where I had a young associate handling a witness who, the next witness was going to be the client, and we didn't want to get to him that day, and he kept turning around thinking he was done, and I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come, as a judge, you sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they are treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill or by filling it with stuff we don't need to use where we could be going to another witness.
All clear for landing.
The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach, if it's specific to that. If it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say it, they'll get it, just let them do their job. I'm assuming that there is, based on our prior motions, agreement, well, I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Yeah, experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I'll want some further clarification with our experts.
And I think you guys agreed that your investigators would be excluded from it as well.
We did make that agreement. I think that may have even been in writing.
Yeah. I'm sorry, I didn't mean to interrupt. I just had that thought and I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is, with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Mr. Thompson? Do you have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to get an admonishment, acknowledgement from witnesses as they appeared.
Bailiff, could you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not the, I'm not wed to the exact wording, so if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness?
Only a phase 2, yeah.
And they attend phase 1, is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to rely on things that.
Are you talking about experts?
Experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on.
What?
I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of to see if the state has a problem with that. counsel who calls a witness unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware?
Hey, no. You know it, baby.
I'm going to,
Ramsland
while we
doesn't
were
talk to
talking about
people
the
who are
jury, I
innocent.
failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines.
Jesus, Judge. Earbud warning. Sorry.
So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, let me. I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony, objection, overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That said, if you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from counsel to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more legroom, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word, and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advance as possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that?
Correct. No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
And I assume you have replacements you have or will get to me for those.
And actually, we had a procedural question we were going to ask the clerk, but I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name, while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared, you may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome.
Yes, sir.
If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is do you want to cross-examine about the information they just presented now, or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And if you don't let them know that, and either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable.
Yes, sir.
Because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them, and then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits?
Okay.
Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that, so I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review? Yes. And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Mm-hmm. Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state, that belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other 2 approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing.
I'm on it.
So oftentimes, and hopefully that's what you're doing, there's an agreement in advance stipulation to admission of exhibits. I generally don't allow pre-admission because what I find is that I admit all these documents that then are never addressed during the course of the trial. And I don't want a bunch of exhibits to go back to the jury that they have no instructions on, that they've had no question and answer with a witness to explain what the relevance of those things are so that they can just go back and use to justify whatever position they want to have from them. And I think that's dangerous. And so the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use Exhibit 6. Witness is on the stand, and just say, Your Honor, I'd like to go over Exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right, Exhibit 6 is admitted, and then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant. right, so that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S-number for its exhibits, and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, it's like to say, the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here, or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab, with the sticker attached inside the exhibit, so that she'll have a box of the opposed exhibits, the originals, and you can ask for exhibit X or whatever, and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the Marshal Service and who to talk to there.
A knife?
We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury, and so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, it'll probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted.
So his
leave that
Glock?
to the state to figure out where it's going to be stored and how it's going to be stored.
He has remember he had a Glock, so his Glock won't be admitted?
With a sister agency, or whether you're going to have the sheriff up there
Thank
bring
you,
down
Vibe.
a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio, and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial.
We don't want that.
All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes or something like that when you have 30 minutes left, so you know. Just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if I have stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not from us, Your Honor, thank you.
far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record, if for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and the presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, you know, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Okay. Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Okay. Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together, so take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think that does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-approve, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, you know, for better or worse, as you know, the Supreme Court in last year in 2024 revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be, if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly, probably the next day, unless it's Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase, and there is a finding of aggravating circumstances, where then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but no, I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but.
Daily versus real time?
So there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
There's separate fees if I want both.
Correct.
May I make that decision?
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
Okay. And we obviously need to know, particularly about the real time in advance, so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at. with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying. During jury selection, if we still don't know if that could come up, the potential jurors should just be aware that it could come up prior to
It'll be
phase
part of
two.
the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss, and so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors, so we'll do that in a closed session. But anything else in the public session we need to talk about?
I don't believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up.
Another break? God almighty.
I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
Is there a spare that we could have?
Bye,
Your Honor?
Marco.
Sure.
Oh, it's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I am going to be entering an order requiring the retention of records by
Bye, Angie.
the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records, all right? All right. Anything else? All right, thank you. Why don't we come back in about an hour, all right?
Jeez, God. We have an hour now? Let's look at inside and outside looking while we have an hour. Want to? Let's do it. Let me see if I can find my video. Okay, let's see. What is this? Taking a look at Bryan Kohberger's steps. Ooh, what's this one? Hold on. I have some good videos, y'all. We went deep. What's this all about? For sure. Do I need to slow down chat, you guys? Oh, God. So there's the bathroom. He may have cleaned some. He may have went in here. I don't know. Do you guys want to watch this one? They're new emojis. Hi, Joe Bill. Look at me. Oh, my God.
Joe Bill.
Oh, my God. I'm wearing the same shirt as I am in this video. Hey, Jason. Hold on. Let me come on camera. I swear to God. I'm wearing the same damn shirt. Hold on. Let me get rid of Elmo. That is weird. Look. Same. I just don't have a hat on. Freak. So I guess I went through the house on this one. Yeah, it will be an hour. So 3:11, about 3 o'clock Eastern. That was an old video, Gypsy. That's not now. This video right here I made in 2 years ago, January 6th of 2023, right after his arrest. On learning D saw him. Yeah, I mean, I'm sure she told him that, hi, Jamie, love you too. I'm sure outside, there's aerial view and all this. What I want to do first is I want to go, because we can drag all around. You guys can let me know where you want me to go. Like, he drove up and down Queen Road. We can go through that later. But I want to enter the house first. So as we enter the house, and we're going to take our time doing this. So if you guys are in a big hurry, you might want to like join the replay crew and put it on fast speed, because I'm going to take my time. Oh, I do, don't I? I do look slimmer. Well, looky there. Going through this here. I want to make it the best I can for you guys to see. Let me get this stupid banner off here. How's that? Better? Okay, so we are inside the house, walking right in the front door. To the right is a bedroom. To the left is a bedroom. I don't know where B, I don't know what her last name is. We'll just call her B, because I don't want to use these girls' names. I don't know what, I can only imagine what they're going through. I'm not here to victimize victims, so I'm just going to use their initials. So do we know which room B was in? Hey, Tony. Hey, Tony. Does it make you feel good to come in and harass a woman? Tony. Bye-bye, Tony. Why, where are you at, Joe, that you're hot? Hi, Potato. Potato in the house. B was in that room to the left. Okay, so over here, bedroom 1A. 6 feet of pure shit. Are you talking about snow? Oh, she was in 1B? Jill, was she in 1P? Or how do we know? Really, Sluice? In Houston, 80 degrees. That's perfect. Nope, it says here this bedroom was vacant. Nope. because we got to read our handy dandy notes. Confirmed as Bethany Funk's room. From affidavit, page 2. 2 of the interviews included BF and DM. It's BF, by the way. BF and DM were inside the King Road residence at the time of the homicides and were roommates to the victims. BF's bedroom was located on the east side. There you go, Mary P. Good job. Of the first floor of the King Road residence. And they have their source. So this is if you're on the bed, this is what the heck just happened? This is what it looks like. So that's the front window. And I think they had curtains, if I'm not mistaken. Or did this window have blinds and the other one have curtains? So she was sleeping in here. Now let's travel back down the hallway because right here is the utility room. And then we're going to go. This is just amazing, isn't it? We're going to go up to floor 2. So now we're upstairs. In the living area. So Bethany is right below here. Or sorry, BM is right below here. Or BF. BF is right below the living area. So then if we go, we're not going to go to Xana's room yet, but if we go through here and look from the stairs to the living area, see this step up? This was like added on or something. So someone who's over here may not necessarily hear anyone who's way over here and up. Like if you're up here, how in the world is BF going to hear you underneath this floor? I feel like BF wouldn't hear anything. So let's continue. So let's go back out in the living room like we do. And we're going to just go around this way. Okay. So when we were just talking about the affidavit, when the cop was walked down this hallway, he was just noting that there's a bathroom on the left and a bedroom down at the end. So there's the bathroom door. And then here, this would be Xana's bedroom. And this is just a rendition, you guys. I don't think this is exactly what it is, but it's like a 2-scale rendition. It's amazing. I had a hard time telling if it was real. But this would be Xana's bedroom here. Okay, so the blood that we all saw dripping out of the foundation would be on this wall. It says this is the wall where a red substance is seen trickling down the foundations at the rear of the house. There is a debate about whether this might be blood or simply a leaking pipe. So I guess you guys can be the judge. That would be the wall. Here's a 3D. Wow. Wow. Can you guys see that? Oh, you can't. Son of a gun. Did I ask you to do that? I wish I could zoom in without losing the... Oh, there we go. I guess I can't make it bigger. Dang it. But you guys get the gist, right? Do you guys think that's blood? It said Xana was found on the floor. So there's not a whole lot of room if there's a double bed in there, and I don't know if that's confirmed to be a double bed. It's awful. Oh, whoever did this has the skills to pay the bills. For real. They're very thorough. I think his name's in here somewhere. I don't know how to find it now. But he has a Twitter account. But yeah, it's absolutely chilling. Because there's not a whole lot of room for that bed if you look at the shape of the room. So do we think she's like between the bed and the floor, like between the bed and the wall on the floor? I think it's blood too. I hate to say that, but oops, I didn't mean to turn on that music. Sorry. Okay, so there's Xana's room. So now that I just wanted to show you guys the bathroom too. Like, so now we're gonna do what we think the killer did, anyways. So we're gonna go back outside. And we're gonna take a look. So this is 11 King Road. Okay, I paused it. This is live, Jay. So now we know that he chased Xana to her room. I wonder where the chair was. Right. I thought it was in Xana's room, but it may not have to be, right? Okay, going back to the video. And this is Sigma Chi. 1 is King Road, 2 is Taylor Avenue, and 3 is Sigma Chi. And I will put the link to this in the description so you guys can obsess on it in your own time as well. A drone of 1122 King Road showing the rear kitchen sliding patio doors, which may have been the intruder's exit and entry. I guess we can't enter the house from the rear. Okay, so we do have to go inside via this route. So let's go through here. And now we're in the kitchen. Okay, so this is where we think he came in. And we know he exited because DM said that he went towards that sliding glass door. So this is the view out of the kitchen patio door. Interesting, though, when you look this way, but when you see the shots that like Fox got, all the photos from, beyond there, like if you were a peeping Tom, what it would look like. And you could literally find spaces to see right between those trees. That's what creeps me out so much. Is looking out, you wouldn't notice that. I mean, you can see that truck up here. So there's a little gap, but from inside the house, you're not going to notice it as much as if you're outside in the wide open looking at their windows. It's just so intrusive to think about. All right. So this right here, this gray, this is also Xana's wall. So just beyond this wall is a neighbor, and that's where the camera was. And I'll show you. Let's go back outside. Sorry. I don't know. The camera. That picked up the sounds is right here. Or right here, rather. No, wait. It must be right over here, this house. Because it was 50 feet from Xana's bedroom. So I'm assuming this house right here is what picked up the muffled barking. Because we know Murphy was right here. Okay? And this is the point I wanted to make. If they heard Murphy, who was right here, muffled barks, this, that. They definitely picked up sound from here. This is way closer to here than this is. So you guys, they have a lot more audio, video stuff. And I'm sure it's chilling if you think about that. If you think about Murphy being locked in this room, barking, think about what was happening in here. Or possibly even in here in the kitchen. Because we don't know where, well, we know they were dead in here, but we don't know if they ran from him. I mean, we don't know what happened. But the other thing I wanted to bring up was the van's shoe print that was in the affidavit as well. They got a latent shoe print. They didn't say the size. They didn't say, if it was the killer's or if it wasn't. So I went back to the photos from that day, from November the 13th, when they did those group photos. And the only one in those photos that's wearing Vans is Xana. Xana is actually wearing high top Vans. Could the footprint have been Xana's or is it the killer's? They didn't specify. All they put in there was that there was a bloody shoe print. So do you think that it's possible it was Xana's? What are your guys' thoughts on that? Yeah. Busted flush. I'm going to go in there. No, the dog was in Kaylee's room. And I think the story about the dog being found roaming was for the killer's benefit. I think the killer put the dog in Kaylee's room and locked it in there. You think it's the killer's shoe print? I know. I was like, why would she be wearing shoes at 4 a.m? I thought so too, Cheryl. I don't see him wearing Vans. And I might be wrong, but I just don't see him wearing Vans. Oh, no, Cujo. They could have several footprints. They only mentioned one in the affidavit. So the affidavit doesn't have everything. To keep the dog out of the way? Let me see. Let me go back to the affidavit and see what I thought it just said a Latin or Latin, whatever, shoe print. Hang on, I'm scrolling to see. So it says, during the processing of the crime scene, investigators found a Latin shoe print. This was located during the second processing of the crime scene. So they didn't find it. And I found some things in here that are kind of concerning. I'm definitely not a lawyer or a detective or any type of professional in this matter. But there's a couple things that I found that I wanted to point out that I thought, yikes, that the defense might be able to pick through. But let's continue reading this. This was located during the second processing of the crime scene by the ISP forensic team by first using a presumptive blood test and then amino black, a protein stain that detects the presence of cellular material. The detective shoe print showed a diamond-shaped pattern similar to the pattern of a Vans-type shoe sole, just outside the door of DM's bedroom, located on the second floor. This is consistent with DM's statement regarding the suspect's path of travel. So they're making illusion. They're alluding to the fact that it is the suspect's with that last sentence, I think. This is consistent with DM's statement regarding the suspect's path of travel. So that's all it says about that. All right, let's go back in and let's take a gander around the house. So we're in the kitchen. This is where the killer would have come in. So if we assume he came in, where do you guys think he went first? Do you think he went upstairs first? Because I do. Xana ordered DoorDash, so maybe she left her shoes on until the order arrived. Right. I don't know where they had DoorDash drop their stuff. No, she didn't see him leave, but they're assuming, and they're not putting everything in. They may have proof that he left through the back door. We don't know. You know what I'm saying? So all we're going off of is what we know, and what we know is in the affidavit. But there's more to this case than what's in the affidavit, for sure. Do I need to slow down chat, you guys? Okay. So if we assume he went upstairs, so he came in and he went up these stairs. Now, in the house, you guys would have to tell me from the Zillow pictures, are these stairs carpeted or are they wood? Because to me, that would make a huge difference. Even with people running up and down carpeted stairs, you'd hear that. So that's one thing that I wanted to talk about with DM being in here. These stairs, you would think you would hear, going up, going down, going up, going down. I mean, he could have tiptoed up, I guess, tiptoed through the tulips. So let's go up. The wood squeaks. Yeah, I think that was one of the one of the people that used to live in that house. Okay, so we're upstairs. Here's the stairs. He comes up. And then it says, I followed Officer Smith upstairs to the third floor of the residence. The third floor consisted of 2 bedrooms and 1 bathroom. The bedroom on the west side was Kaylee's. I later learned from a review of Officer Nunez's body camera there was a dog in the room when Moscow police officers initially responded. The dog belonged to Gonsalves, I'm trying to say her name correctly, and her ex-boyfriend, Jack. I found from my interview with Jack on November 13th, he talked to Jack on the day of the murders, that he and Kaylee shared the dog. And then Officer Smith pointed out a small bathroom on the east side, and this bathroom shared a wall with Madison Mogen's bedroom. So I don't know why Officer Smith pointed out the bathroom, because there's nothing in the affidavit about the bathroom. But there could be something that we don't know. So there's the bathroom. He may have cleaned some, he may have went in here. I don't know. Just a little half bath with a shower. So this is the room that Madison and Kaylee were in. This is Maddie's room. And it's small, and they were both on this twin bed together. Exactly. I think so too, Kaylee. I later noticed what appeared to be a tan leather knife sheath laying on the bed next to Mogen's right side when viewed from the door. The sheath was later processed and had K-Bar, USMC, and the United States Marine Corps Eagle Globe and anchor insignia. Okay, this is me, live. So the sheath was laying on the bed next to Mogen's right side. And we know now that Kaylee was also on the bed, right? She thought they were playing with the dog. Right. She said she thought Kaylee and them were playing with Murphy. Nia stamped on the outside of it. The Idaho State Lab later located a single source of male DNA left on the button snap of the knife sheath. So right here is where they found the male DNA. And then this is looking down on their bed and then looking at the door from where they were just sleeping. And so if you check this out, that knife is not straight from like a Marine insignia. If you buy the straight edge, this is the most famous figure two from. So we dug into the K-Bar. Let's skip this. We went over the K-Bar knife. Now let's go here and see what I'm talking about here. Oh, Lord. I'm going to show you guys the Albertsons. Let's go to Albertsons now. Google Earth. God, I do look lighter. Jay Hughes in it. There's the Albertsons right smack dab in the middle of your screen. So let's go. There's a Costco. Usually where there's a Costco, there is some kind of, I don't know if all of those stores still exist, like Gander Mountain. But let's take a look. Let's go down to Albertsons. And he went to Albertsons before the murders. Okay, that's what I believe. If I'm wrong, correct me, but I could have sworn he went before. And that's why I was wondering what was in this area, if he possibly went and bought the knife. Look at those mountains, y'all. It is so pretty there. See, I didn't know. We didn't know this, what we know now. So let's skip past this. I want to know what he bought at Albertsons. Okay. Well, we won't know until he went to do something to be. God, remember Hell's Canyon security? He was at Albertsons at 12:45 on 11/13. So he went to the Albertsons right after the murders. Thank you for clearing that up. Cujo says there's some scary knives you can buy from Amazon endorsed by Sylvester Stallone. Sylvester Stallone. Nope, Crime Solver. That's the standard sheath that comes with that knife. So it's not specially. No, I don't. Kaylee and Madison were found in the same bed, and I think we're to assume that they were sleeping, but we don't know for sure. We don't know who had the defensive wounds. So now we do. I just paused it. This is me. Now we know Kaylee had all of the wounds, and so did Xana, and so did Ethan because his legs were carved. Now remember, it was reported early on by Annie Elise that his hamstrings were cut. Remember that? Well, it wasn't his hamstrings. It was the back of his calves. He does that, but this is the room that Murphy was in. This is Kaylee's room. So Murphy is in here running around. Part. This room and this room, the bathroom and the bedroom, are right above DM. So would she hear also if there was running around in here? Because if you remember, she said that it sounded like Kaylee was playing with her dog. Here we go, right here. Acor. Oh, you think Kay was chased from her room? Okay, so someone said they think Kaylee was chased from her room, but now we know that's not true. But Xana went to check on the sound. She got the info from Mike King. What's the name of his podcast? Mike King. The fuck's it? What is it? Mike King. He's always smiling. Ugh, I can't remember the name of it. Was there another store there that he went to and they didn't need to put that in there? Mike Sanders says, I could be wrong, but I think the military use a hard case, not leather. At the sound that DM heard was Murphy running around, and it sounded like he was being played with. It's interesting to note the kitchen is right below this room. Then we go back in the hallway. So here we have the two rooms over DM's room. Didn't he work for the FBI or something? The better question is, why would he give it to her? Why did he give it to her? That's the question. Something. Haley and Madison were found in here. Now Vibrator, we've since found out that Bryan was covered head to toe with the exception of his eyebrows, eyes, and a little bit of his mouth. So he would have no marks because he was covered. We do this, we're the killer, right? Path O the killer. God. Someone could have gotten in their house and went in this attic. I mean, we can only really speculate, need some Z's, right? Because we don't know. We don't know how. All we know is they ended up in here together. We just don't know how they ended up there together. We just know that they did. And there's that trap door for the attic. You know, when you open those, like a ladder comes down. So he does what he does up here. Well, I think the only light that maybe was on was the good vibes sign. And I'm just assuming. I'm not, don't quote me on that, but it seemed like when they were there investigating around, they were doing it with just that good vibes sign on for a while. So he does what he does up there, and then he comes downstairs. So he's coming back down the stairs, and this coincides with DM's account, okay? So we're going to go through and read DM's account at the same time. DM stated she originally went to sleep in her bedroom on the south. And I don't know why the word originally is in there. I don't know why that would be there. Okay, because originally she fell asleep in this bedroom that we see right here and ended up in Bethany's room. But we didn't know that at the time. DM stated she originally went to sleep in her bedroom on the south side of the second floor because it makes it sound like she went to sleep somewhere else after that. And that's what's confusing. And maybe she did, and that's not in here. But it's just the weirdest wording. She originally went to sleep in her bedroom on the southeast side of the second floor. So did she come out when she was woken up by the dog and shit and go down to a downstairs bedroom? And we just don't know that? I don't know. Yep, she did. Ooh, thank you so much, Jeff H. By what she stated, sounded like Gonsalves playing with her dog in one of the upstairs bedrooms, which was located on the third floor. So that's the playing with the dog thing. A short time later, DM said she heard who she thought was Gonsalves say something to the effect of, "There's someone here." So this is my Diddy87. Thank you for looking that up. So Diddy87 looked up the Sherman's True Value that we mentioned, and she said it's very close to Albertsons and sells knives and also used knives. Very interesting. True, Mary. I mean, that's the only thing. They DM stated she went to sleep in her bedroom. Why do they have to put the word originally in there? You need to use. Is who upset? Hold on, I just paused it. Vibe, are you talking to me? No, I'm not upset. I get passionate about this case. I mean, it's been 3 years waiting for this trial. I'm very, very ready for it. But no, I'm not upset at all. I just don't blame the roommates. That's all. If DM, yeah, Tam, I am. Oh my God, I wish I could pin your comment. Tam, I am. Okay, so they put the word originally in there. Why? Because to use the word originally, you would have had to have ended up somewhere else after. To originally be somewhere, and then later you're going to be somewhere else. So maybe that's not included in here. And wow, bing bong. Her phone was like plugged in, and she ran really quick from one room to another. Did you hear that? Did you hear that? Remember the text where DM says, "My phone's going to die. Fuck." Listen to what Jay said back in January of 2023. I'm going to become the next Pat Brown, the self-taught investigator, armchair investigator, self-taught. So maybe that's not included in here. And her phone was like plugged in, and she ran really quick from one room to another and didn't have her phone. And that's why she sat there, because she was scared stiff and had nothing to call for help with. We don't know. But the word originally is interesting, and it may or may not be anything. Hello, CEO. Oh, Lord. This is interesting to look back on. Of hers said that she went, Marina Girl says a Facebook post said a friend of hers said that she went to the first floor after he left and stayed with the other roommate. Said they didn't call police because she just did a Molly. Don't know if it's true. Who does a Molly and then goes to bed? Ha, thanks, sleuths. Russian, aloha. I love you, babe, and I appreciate you and your chatting, but I had to delete your comment because we're not going to go in any direction of those roommates holding any responsibility and bearing any responsibility for these murders here. We are erring on the side of kindness here, and until we hear something else. Exactly. They don't go to sleep after they take a Molly. Bing bong. So I don't think that's true. So just everybody know that. I'm just going to say it. We're not going to, in any way, shape, or form, like, infer that these girls had anything to do with it. All right. So, and if she did a Molly, it has nothing to do with her being killed. Or with her friends being killed. I know. I do too, Russian. I do. You know I love you. I have to be careful. Albertsons would open early. Now, why do you think he did Xana and Ethan's room first, then went to the third floor? We know EDKH. How do you know that? We don't know how many interviews they had, though. And originally is not talking about the time of the interviews. Absolutely not. They don't put that in arrest affidavits. I agree, Sam K. Crime Solver, I already said I think it's Xana. I think Xana left a footprint. I think there's a lot of footprints. I mean, if you're going to go for the two girls, I mean, this DM is 19 years old, you guys. 19. We have grown men coming at a 19-year-old. Whether or not you agree with her actions, she's 19. And four of her roommate or four of her friends were brutally slaughtered. Just a baby. My son survived an accident at 16 and still has major survivor's guilt. And
we're gonna skip that part. I don't want to go into that.
Kaylee playing with the dog murders started on third floor, in my opinion. Unless Kaylee was playing with the dog. Wait a minute. What if Kaylee was playing with the dog? And that's when it has not been mentioned, Jeremy. I don't know if he's been in there, but you could study it from Zillow. Yeah, Mike Sanner. No, they're saying, give me my box. Hey, Gons. She should be thankful she opened her door to see that scumbag. Yes. Matt Bond, thank you for your super. Hold on. You guys are not hearing people that are here right now. This is from the stream we're playing, y'all. That's why I hate replaying these things. It gets so confusing. I like the info. These two girls have grown men coming at them. This is way too horrific. And we only know part of it. We only know part of it. We don't even know the whole thing. We don't know what she saw. We don't know what she heard. I mean, can you imagine what it's like for her when it's time to go to bed? I can't. It actually makes me it makes my insides tighten up and feel sick to think what she goes through when it's nighttime. And if you can defend anyone who is re-victimizing that girl, I'm sorry. I get emotional over this shit. She's a kid. To me, she's a kid. And I don't play that with kids. Okay, enough about that. So he does what he does upstairs. We're just going to assume that he went up there first. And it might have been other ways that he did this. We're just going to go through this one theory. And then he comes down after that. And DM, for all intents and purposes, from what we know, is in this room. And, you know, I think it's interesting to see this too, because how the door swings open. So if you picture, you know, her cracking the door open when he's coming this way, he may not have seen her. And I'll show you more of what I mean. We don't know if she originally went to sleep in one room and ended up in another room with no means of calling. Even if she had her phone, she may have been scared to fucking move. Like if you heard your roommates get killed, and I'm pretty sure she did. If the shit was caught on a camera next door, 50 feet from Xana's room, she was a hell of a lot closer and way closer in earshot. There's a reason that girl didn't move, and it's not because she's in on it or she didn't care.
All right, Jay.
She was sleeping. Come on, mods.
Oh, I was heated during this stream.
This is Bethany's room, or sorry, Dylan's room. So she heard who she thought was Kaylee say, there's someone here. So this is what I wanted to ask. Do you guys think that Kaylee said it scared? Okay, so now we know we saw Bryan Kohberger's car pull in, right? For the final time at 3:59, went around to the back. It says here she was awoken at approximately 4 a.m. by what sounded like Gonsalves playing with her dog in one of the upstairs bedrooms. A short time later, DM said she heard who she thought was Gonsalves say something to the effect of "there's someone here." A review of records obtained from a forensic download of Kernodle's phone showed that this could have been Kernodle, as her cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12. DM stated she looked out of her bedroom, but did not see anything when she heard the comment about someone being in the house. DM states she opened her door a second time when she heard what she thought was crying coming from Kernodle's room. DM then said she heard a male voice say something to the effect of "It's okay, I'm going to help you." At 4:17, a security camera at 1112 King Road picked up distorted audio of what sounded like a voices or a whimper, followed by a loud thud. The dog can be heard barking numerous times, starting at 4:17. The security camera is less than 50 feet from the west wall of Kernodle's bedroom. DM said she opened the door for the third time after she heard the crying and saw a figure clad in black clothing and a mask that covered the person's mouth and nose walking towards her. DM described the figure as 5'10" or smaller, not very muscular, athletically built with bushy eyebrows. The male walked towards the back sliding glass door. She locked herself in her room, and then that's all I can see. Scared? Oh, thank you, Flobo. Cindy E., welcome. Welcome to the channel.
There's someone here. Like, there's no expression related to that statement. So it could be that she just heard someone say, "There's someone here." Like, oh, if you're expecting someone, someone's here. Could that have been the DoorDash? It was around 4 a.m. A short time later, DM said she heard who she thought was Kaylee say something to the effect of, "There's someone here." But who would Xana have been talking to if Ethan was sleeping? Or do we think Ethan was sleeping?
So Murphy went outside and started barking.
Because they left that open for interpretation, too. They put the roommates were home and either sleeping or in their rooms by 4. Four o'clock was around the time. All this says approximate. Approximately 4 a.m., she heard the dog being played with in one of the bedrooms upstairs. And then she thought she heard Kaylee a short time later say, "There's someone here."
Okay, we're going to skip that because I read it.
And that was where she was. We thought that room was empty.
Hold on, let's go back.
This window. But I would have been in here, in this closet, absolutely frozen, unable to move, in an abs.
Because he didn't shut the slider behind him. He only touched it once to come in, and that's why Papa Rogers said that they removed the outside handle of the sliding glass door, not the inside part, because he only touched the outside part.
Absolute state of shock. That would be me. And then she's got this window here, and they focused a lot on this window with fingerprints and all of that. Remember, they were dusting this? And that was where she was. We thought that room was empty, but it was confirmed to be the room she was in. So right above here is Maddie's room. She would have heard everything, guys. She heard everything. He didn't have Instagram until his name was made, or until his name was made public. We watched it happen in real time. He had no Instagram account, this dude. Until his name was put out there, a bunch of fake accounts came up and started following Kaylee and all the other girls. It's fake. Isn't it just a damn shame that the DoorDash driver, the timing wasn't able to deter him from hurting them? Tim Allen, thank you for your super chat. Jay, the screen door was pretty loud when opened. Remember the first noise complaint with Kaylee, when she came out, the door was loud. Oh, the screen door was loud when it was opened. Hole in One just gifted 10 Roberters. Holy shit! Here we go. Thank you so much. We've got some witness. She saw the bushy ass eyebrows. I can't even keep up with who's all members now. You guys are crazy. Birder had boxes stacked up in it, remember? Because of that case. That's why. I think he probably, yes, was totally Googling. They will find shit on his computer as well. Think about that. His phone, his computer, anything else that they got out of his apartment. Because if you look at the look on his face in that body cam, he was not expecting to get pulled over or caught. Okay, so DM opens her door, sees him. Okay, so anyways, he comes down from the upstairs. That's where we were. And he has to go here, right? So this is where he came from upstairs. Down this hallway, this is Xana and Ethan. All right, so God, that's just chilling, isn't it? That's what it looked like the night of the murders. That gives me goosebumps. This photo, it says, photo taken in the living room by this picture. This is Kaylee with BFDM before the murders took place. Standing in front of that sign. I've never seen this photo before. Oh, okay. I will, Olive. That's a good one. And then this is, he could see a body identified as Kernodles laying on the floor. As he approached the room, he could see a body identified as Kernodles laying on the floor. And also in the room was a male, and they don't say where Ethan was. They just say he was in the room.
Well, we know now he was on the bed. So, yeah, we just went into Xana's room. So let me go back, Sleuth. Xana's room is at the end of the hallway here. There's a bathroom on the left, and then there's her room.
So that's the bathroom here. And then this is where Xana and Ethan were. As he approached the room, he could see a body identified as Kernodles laying on the floor. And also in the room was a male, and they don't say where Ethan was. They just say he was in the room. So if we go back, wait, let's go back over here and look down that hallway.
He chased
Picture that door being open.
He chased her down that hallway.
We don't know how far it was open, but you can see the edge of the bed. And you see the edge of the bed, and Xana was on the floor. So I don't know where. But as he was walking down,
so perhaps you could see her feet with this door open, right? And her head was up towards the wall to the left. And maybe there's a rug where maybe she could have passed out, because Xana was a big drinker, right? From all the videos and photos I've seen, she was the big drinker out of the bunch. So she might crash on the floor a time or two. We are on lunch break until they come back. Probably about 5-10 more minutes.
in this hallway, approaching this room, he saw a body before he even walked in the room. I don't know where Ethan was. I don't. And the wall. See this little space? Now, 1B is below. And we're not sure where the other roommate was, as far as I know. We don't know if she was right below Xana's room. She may have heard everything as well. She may have heard this struggle. If she was in... Ethan was by the well, that's why all the blood... Because right here is the foundation wall. See how small this wall is here? That's the part that sticks out right here. No, it doesn't state where Ethan was found. It says right here. Hold on. This is chilling. That view is chilling. It says Kernodle was deceased, and then he went back in there and killed her. Don't worry, I'll help you, and then killed her. What if that's what happened? What if Xana was wearing her Vans, went outside to get the DoorDash, he come in, attacks Ethan in bed, who was sleeping, and she comes in from getting the DoorDash, finds Ethan, she's crying, Kaylee says, someone's here, he's up, goes upstairs, they have the scuffle, he kills Kaylee and Madison, then he hears that Xana's alive down there, and he goes in there and says, don't worry, I'll help you, and he kills her, and then he leaves. And the dog starts barking. The dog starts barking, and that's why he just beelined right out of there. He may have seen her, he may not. He may know that she saw him. And who knows? Like, if he knows that she saw him, that could be why she was so scared as well. I mean, there's enough to scare her. And I don't think I can repeat that because I don't even remember what I just said because it just came to me. But let's go. Appears they have loaded mattresses into the back of several pickup trucks. They haven't taken their mattresses yet?
Wow, this is when they were taking these out.
She had like a dog gate, like a pen. Yeah, these are wrapped. I can't zoom. Dang it. Guys, what's in this? What's in this jug over here? What is that? This guy says you can see blood stains right here under the cover they put on it. Well, I think they wrapped them in these white things. Look on the top right corner.
No, we found out, Pickle, that he was on the bed. He never got out of the bed. Where is it? Pickle, can you email it to me? I couldn't find a picture of her room.
Bryan oh, really? Oh, Olive, I'm so glad you saw that. Bryan does own Vans. Olive, hi, Justice Jane. Olive just confirmed it. 22 King Road, including the home, its outbuildings, trailers, vehicles, shall be preserved, which means the house will be locked. Crime tape will remain. On-site police presence is not required. The crime scene will remain preserved until February 1st or until further order of the court.
God, that's when we were still with Judge Megan Marshall. God, she with her bubble letters.
Murderer went out this way, right? The male walked towards the back sliding glass door. DM.
Yes, and I said I bet Pennsylvania was on there on purpose. The same reason that the DA went walking through the neighborhood in a mechanic's jumpsuit. I bet he shit himself when he saw that too.
Locked herself in her room after seeing the male. DM did not state that she recognized the male. This leads investigators to believe that he left that the murderer left the scene. So for her to get out of this room, she had to go, if she went through this way, which I wouldn't, because that's where I last saw the killer go. So I wouldn't go this way if I was her. I would go to the front door. I would make a clean break right for the front, where when I go outside, everybody can freaking see me. And there's nothing to, you know, hide me, like trees and all that shit. This is wide ass open. I'm going to run over here and I am going to go downstairs. But when I go down that hallway, if I look down there, the cop saw a body. You think she didn't? You think she didn't? I would think that she would see. If she looked down there, she might see a body. And I think she heard all the struggles and the crying, and who knows what she heard after the crying, when the crying stopped, or how the crying stopped. What if she had her door cracked open while the crying stopped? Maybe she couldn't bear to look because of what she heard. You're right. But she knew the severity of this, of what happened. And I would have run down these stairs and either to my friend who I knew was in here or in that other room here, or straight up out this door. And I would call someone and I'd be like, I need you to come over here right now because I don't know what fucking happened here and I'm scared to death. Or she said, they're dead. They're all dead. She may have known they're all dead. We don't know what she said to those.
Well, we do now. We do now. So what's this? I don't think I don't think they could see the blood, right? Mattresses, clothing in the dark soaks up blood. I don't think they turned on all the lights. I think they knew something bad had happened, but were scared.
Weird that we haven't gotten a press conference from the prosecutor in this case yet. He had his arraignment. Why haven't they given a press conference?
Here, I'm bitching about them not telling us anything.
And go there anymore. It's that, and you can't drop the little goose. All right. Well, we're going to do a deeper dive into the Google Earth and also.
Hold on.
For quite some time, and we've talked about that. I've asked them, and they said that they want to be steadfast. They want to make sure that this process is as thorough as possible, and they want to make sure that the killer is brought to justice. So,
all right.
How can something like this be left behind? And I know there's a theory that possibly sometimes killers leave things behind on purpose. Where's your head at on this one?
Yeah, there have been some reports. I don't think they've been confirmed yet, but I've seen reports that there might have been signs of a struggle, at least with one of the victims. There's some evidence perhaps of defensive wounds. We've got to wait to see how that comes out. But if there was a struggle, even
Garagos is coming up, guys, I promise.
Multiple stab wounds, which is what this affidavit speaks to. Yes, you could actually lose the sheath. It could not be buckled properly onto your belt, or it could have come loose. Or as you suggest, we could be dealing with someone who's simply too smart for his own good. He might have thought, I'm going to leave this behind and see if they catch me. I don't know, but as Jim says, this is a dream come true for forensic experts. You've got his DNA not only on the knife sheath, it's on the snap button, meaning that's what he would have had to engage to remove the sheath. So right. There's also great evidence. How did they get the DNA? They pulled it in Pennsylvania off the trash from his parents' home.
Yeah, the police work has been incredible. I do want to bring in someone else into this conversation. Famed criminal defense attorney Mark Garagos, who's represented everyone from convicted killer Scott Peterson to Gary Condit to Michael Jackson to Jussie Smollett. Mark Garagos, thanks for joining us right now. You've defended people who are guilty. You've defended people who are not guilty, high-profile defendants. Does anything in this case right now worry you as far as the legal investigation is concerned? Is there anything investigators left out possibly, or do you see any mistakes so far, or do you think this is a pretty tight case?
Well, I'll tell you right now, I don't want to disagree with my two friends and predecessor commentators here, but this is hardly an open and shut case. In fact, I think that the reason that this is such a detailed probable cause affidavit is the police were pushing back against a lot of media speculation and the public's perception that they weren't doing much. Frankly, I will tell you that there are some gigantic opportunities for the defense here. First of all, this is not a one-on-one match of DNA yet. If you read the probable cause affidavit, they've excluded.
Okay, so he's saying he's going to talk about the dad's DNA being used. But we have to figure, okay? The defense can try all these things and delay and be a pain in the ass. But if it's 99.99 whatever, his dad, I mean, it's got to be his. But they're going to, he's talking about arguing semantics. But this did worry me a little bit because I do have a lot of respect for Mr. Garagos as a lawyer.
Included 99 point whatever percent based on the father's DNA, not his DNA. So they're going to obviously take a swab from him if they haven't already. That's number one. Number two, the supposed DNA found on the button, that doesn't mean a thing. If it was on the knife, I would grant you that that would be something. However, on the sheet, there isn't anything that they talk about that is going to take you beyond a reasonable doubt on that. Number three, the other glaring hole that they're going to talk about is there's rank speculation that somehow he must have turned his phone off, because the problem is, and I was wondering about this because I've had it in so many murder cases, I assumed that one of the first things they did was go and take a look at the cell phone service. Now, the cell phone service is not like GPS. Cell phone service is when you got a phone.
This worried me because we know when the YouTubers were out at King Road, they did not have cell phone service. So good thing they have the videos.
Oh my God, I was muted saying goodbye. Fuck. I said tomorrow we'll go over all of Papa Rogers. I don't even know what I said. I said tomorrow you'll be redirected to tomorrow's stream, which will be us going over Papa Rogers, all the Facebook posts. And after this short little intermission, you will be redirected over there for tomorrow's stream. I don't know what I said before that, but I'm out of here. I need to get shit done. And court is over, officially over. Was I muted the whole time? Court's over. No one's streaming. They're done for the day. You didn't hear any of that? God almighty. Lord help. Yeah, court is over. Everyone is done streaming. They're keeping this one behind closed doors. Thank you guys for being here. I'm sorry I kept you longer than I needed to. Jesus. Have a laugh on me. Have a laugh on me. I said I got to get some stuff done. I'm sorry that I kept you guys over. So we'll roll our credits again. And I will see you guys tomorrow. You'll be directed over to the next stream. Hit the notification. You'll be notified before it happens. And I'll see you in the next one. I'm so sorry.
about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. 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 You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact